I know you're not feeling well. I know you'd rather be somewhere else. Probably don't. But were you here for the testimony of Mr. Gross?
Yes.
Okay. Did you hear his testimony clearly?
I did.
Okay. I think as we talked about earlier, you live right across the cove from the Emerson Lake House, correct?
Correct.
You were identified on Miss Emerson's exhibit that I showed before as being the white house that's across that way, correct?
Yes.
Okay. I'll just show you. This is Opponent's Exhibit 4 here. This is the map. Okay. I think 124 is identified here. On the other side, and I'll show this to the board, is this your home here on the end?
Yes, it's approximately 550 feet porch to porch.
Okay. If I may approach the board and sort of give you all that's the Emerson property. That's Miss Robinson's, right across the cove. Miss Robinson's porch. There was testimony from Mr. Gross about the lights being on every night. Is that your observation?
Yes, I'm not sure I made it very clear in my previous testimony. Because I'm not speaking very well. Can you hear me okay? I do look at those cameras every day, in the morning, in the afternoon, and in the evening. And I also look at them sometimes at night, actually often at night, I would say. Because I kind of look for a sunset, to be honest with you, and I miss it a lot of times. So the Emersons do keep lights on, and I keep lights on actually at my house as well. Not as many, I used to have them on timers. It's my observation that when they are in residence, the place has more lights on and there's movement, on the property. So I'm just adding that information if it is of benefit to you as the board in your decision making.
So essentially, they have lights that are on automatic timers that come on every day, correct?
All right, it's very typical at the lake that people do this.
So lights can be on, but that doesn't mean they're home, does it?
Correct, and the proverbial saying, the lights can be on, but no one can be home. And that's true of my house too.
Thank you.
Thank you.
Is there any questions?
Yes, I have one question I have about your security camera. Does it work all the time?
Actually, it works, I would say, 85 to 90%. I had a lot of work by Zito done at the house and on the equipment, and I have 200 megabyte service. And so the cameras notify me when they do go down.
Did Jack Rose ever call you and tell you that you had someone on your dock or on your porch because your cameras were not working?
Well, yes, one incident, but on a separate time, some hoodlums were on my property tearing up something, and I called it on the camera and called the deputy and actually talked to the deputy on their porch. So, there can be singular incidents where the cameras aren't working for sure.
Susan, do you know our intent?
I don't.
Thank you very much.
Does the board have any questions on Ms. Robinson?
Just one follow-up. You were asked whether you know the Emerson's intent, Ms. Robinson, correct?
Can you speak up, Mr. Turner, where I apologize?
You were asked about the Emerson's intent, Ms. Robinson, and I think you realize you don't know their intent, correct?
Right.
Got it. But you do know what you see across the cove, correct?
Correct.
And you know, and I think your testimony from beforehand was that consistent with the pictures that were taken, you rarely see them at the house, correct?
That is correct.
So despite what they might say, they're not there.
Right. And it's been confusing to me because I bought a boat here, you had to live here. And so I'm not, this intent question confuses me a bit, I must say.
Thank you.
Ms. Emerson, do you want to comment?
Susan, how often have you been here this year? You said that you have taken care of your mother this year?
Yeah.
Yes. So you haven't been here very much in the last year?
I come once or twice a month.
Once or twice a month?
And I just want to check the cameras all the time.
Okay. Thank you very much.
Thank you.
Mr. Ward, have any? Thank you. Mr. Ward, do you have any more to ask Ms. Robinson?
Just one more. Ms. Simon will recall. Mr. Barlow.
Ms. Simon, I want to remind you that you're still under oath.
Yes, ma'am.
Ms. Simon, there was testimony offered about Ms. Emerson and how they used the Matthews property as their P.O. box. Do you have a P.O. box?
I have a P.O. box.
Your residence is in the town of Lake Santeetlah, correct?
Yes,
Okay. Where's your P.O. box?
it is at the Robbinsville Post
I'm sorry,
Office.
that's object for relevance.
Overruled.
That's my only, those are my questions for Ms. Simon.
Ms. Emerson, do you want to read it?
Diane, earlier in your testimony, you said that you drive by our house and you have not been on our property when I asked you that. You said, no, you don't go on people's property. Have you ever been on anyone's property that was not your own, that you were not invited?
So I'll object to this being outside the scope of a rebuttal. I mean, she would ask about a P.O. box. That's the scope of the cross-examination.
Sustained.
I have nothing, thank you.
Mr. Ward? Thank you.
I have no further rebuttal. Please.
The trial attorney has the right to open and close an argument. Mr. Ward?
Just give me a second while I get and see what my children watch. A lot of the testimony that you've heard today revolves around intent. What is Ms. Emerson intending to do? I think we've all heard it. Actions speak louder than words. What someone does matters a whole lot more than what they say. And that's not just me saying that. That's what the Court of Appeals says. We pulled that up earlier, Farnsworth case. I'll just pull it up again. Although a person's testimony regarding his or her intent regarding the acquisition of a new domicile is competent evidence, it is not conclusive. This is what the Court of Appeals says. We must consider all of the surrounding circumstances in the conduct of the person to determine whether he or she has effectuated a change in domicile. That's what we look at.
I object because the word domicile is not in the law and not what
Well, and
I... Okay.
I'll just pull up the same case. Term residence is used in our state's elections law. It's synonymous with legal domicile. That's the law. And we look at what they do, not what they say. Throughout this process, the other, another important part here, again, this is the law. It comes straight from the North Carolina Supreme Court. Where someone retains his original home with all its incidental privileges and rights, there is no change in domicile. Ms. Emerson testified that they bought the Matthews house in 2004. She testified that they continued to reside there. She testified that they still own the house. The law says they've not changed their domicile. Let's look at the rest of the way. Again, what did they do? What did they promise to people? The Matthews house. That Matthews house deed of trust has them confirming to their lender that they will use that as their principal residence. That's what they're promising on a mortgage. More importantly, we presented to you information about the Santeetlah property. I want to throw that up for the board. What did they say in 2017? When they refinanced the house in Santeetlah? Second home rider. That's the title of the document. Borrower shall occupy and shall only use the property as borrower's second home. That's what they promised their lender. That same year, Ms. Emerson changes her voter registration from Mecklenburg County to Graham County, but just for a year. Then switches it right back. These aren't the things. Think about what you do. Do you go switching your voter registration to different places based on where you want to vote in a particular year? Do you leave it where you live? There was testimony offered, pictures over and over and over that showed no one at the house, testimony that no one was there on those days, and no presence of the vehicles that Mr. and Mrs. Emerson used for the white Volvo or the black Suburban. No evidence. That was presented by both Ms. Simon and Mr. Taylor. No evidence was offered in the rebuttal saying that those pictures were inaccurate. Other pictures of the paper here, but no evidence saying that that was accurate. When you add up those days where the testimony indicates that they were not present in Lexington, exceed the number of days where they spent over 50% of their time outside of the town. Again, that's not consistent with someone who says, it's my intent to reside in a place. Do you spend more than 50% of your time in another location? We also have to look at the voting. We talk about the political donations. Even after she submits that registration project, she's still making donations and still listing the Matthews address as her location on those political donations. She admitted to numerous occasions her bank records to Matthew's house. All important documents come to Matthew's house. Everything goes to the Matthew's house. Do you all have important documents that you send to a location that's approximately 4 hours away from where you actually claim to reside? That doesn't make sense. She admitted that her driver's license lists her address as in Matthews, North Carolina. She also admitted that contrary to what the law requires us all to do, when you move, you change your address. She's never let DMV or anyone else know to change that document. When you think about the totality of all of this, what you have is first-hand accounts with picture evidence that she's not in the town. We have evidence in her deeds for both properties indicating that Matthews is where she lives, and that she shouldn't and is promising not to use the Santeetlah house as a primary residence. You have voting records where she's flip-flopped her voter registration in the past. None of that is consistent with being a resident of Graham County. And why does this matter? Why have you taken an entire day out of your time to be with us instead of working? Because elections matter. People have a right to vote where they reside. And Miss Emerson doesn't reside in Graham County. All of the actions speak to that. And it matters for you all. You had a very contentious, I don't know if I heard that, and I looked at the vote, but it was contentious about whether to have beer and wine in the last election. Not everybody agreed on that. Heck, in most communities, most people don't agree on exactly what should happen. But that's why only residents should be voting. What if that vote could come down to 2 or 3? That's why it matters that only residents maintain their voter registration. You have to reside, because only Graham County residents should be making decisions on Graham County issues. Whether that's in the Lake Santeetlah, whether that's a ballot initiative, whether it's county commissioners, whether it's other things. We appreciate you taking the time. And I'll end where I started. Actions speak louder than words. What are the actions here? What has she done? Not what she said. What has she done? Tina Emerson just isn't in, isn't living, isn't residing in Lake Santeetlah. And we'd ask that the board sustain the challenge and determine that she is unlawfully registered to vote at the address she's in. Thank you.
Ms. Emerson, can we have your argument?
I'd like to apologize for the lateness of the night. It's just, the day has gone on, and I'm very sorry that you guys have to be here this late. I'm not as eloquent as Mr. Norm, I'm not an attorney, so I can't go on off the top of my head. So I've written down a couple of things that I would just like to read to you. When I registered to vote, I read the statutes and I read the application. And the application says that I intend to reside here and that I would be here 30 days before an election, and that I have a right to register and vote. And everyone who is a qualified voter has the right to vote. And I feel like my right to vote is being taken away from me, even though I followed the rules and what I thought were the rules. There's nothing in the statutes that I could find that says that you have to spend 50% or 50.1% in any one place. And that if you're gone, you have to keep track of where you have gone or where you've been. And otherwise, anyone could leave and be challenged for their voter status. You could leave to go take care of your family in another state. You could go on vacation for an extended time. You could work for Phillips and Jordan and be sent out to Texas or to any other state. And you're not supposed to be afraid that you're going to lose your voter registration. We registered here. We received a postcard that verified that the Board of Elections said that we are now certified to be voters. And there's no time period that you have to be here. So I don't have to count the number of hours or minutes or days to show that we're here. Every time that we're here and we leave, we intend to come back. If we didn't intend to, we wouldn't. We always intend to. And we own 2 homes in North Carolina. We're very lucky, as my son says. It's a first world problem because there's lots of people that don't even own 1 home, and we're very thankful that we have more than 1. But our intent is to be here, and that's why we changed our voter registration to here. People vote, as you could tell from looking at my voter registration. We vote. We vote where we live. We always have. I'm from Maryland. I registered to vote in 1982. I graduated from high school in 1982 and registered to vote in 1982 and voted. We lived overseas and we voted. We lived in California and voted. We lived in Virginia and voted. And we lived in North Carolina and voted. And the fact that we've moved around and now we like to be consistent and having our mail go to one place shouldn't be held against us. Nowhere on the record that I signed did it say that I had to have my taxes done at a certain place or that I have to now have a P.O. box in Robbinsville. What if I had a P.O. box in Murphy? Am I not allowed to do that either? So I have more of a statement here, but from my understanding, John's understanding is our intent is to be here. And if we intend to be here and we follow the rule that we registered to vote 30 days, more than 30 days before an election, we were qualified to be voters as long as the law was filed, that a card was sent to our mailing address here, it was not returned to the Board of Elections, and that basically certified to the Board of Elections that yes, we're allowed to vote based on the National Voter Registration Act, that we're allowed to be here. And I hope that everyone will just understand that's where we're coming from. We're not, like I said, eloquent. I don't know when to object or not object. And thank you for offering to help with the exhibits and also for giving us the time to put that in the correct form that you guys needed. And I believe that's all that I have to say. I hope that you will give us the opportunity to stay here, to be here, and to vote here. Thank you.
I just want to remind the board again of the law. This was the certified mailer that was returned to Ms. Simon. And as we presented, I'm happy to put the statute up if the board needs it. This constitutes prima facie evidence that the voter no longer resides there. That's what the law says. Okay. That's been provided to you. It was mentioned during the last hearing. I even provided the Supreme Court case law that says what that means is that we've met our burden. We've presented all the evidence necessary for you to conclude that Ms. Emerson does not reside in Graham County by this coming back. Not only did we do that, He then provided slews of additional evidence in the form of pictures, etc. Again, Ms. Emerson can tell you what her intent is. Any given minute. What you have to look at is what has she done? What did they do? And that evidence shows you that she is not a resident of Grand County. None of it is consistent with what she says her intent is. Thank you.
Board will now deliberate. Does the board want to discuss the issues, or would anyone like to make a motion to entertain?
I have just a couple of notes here. First of all, I would say I really have concerns about how the law is written to handle a situation like this. I think it needs to be revised and done better. And I can see how, understand maybe how one could see that someone might be ineligible because they're not at a particular place as much as you would like them to be. Nevertheless, as a board member, we've got to go by what we think is the law as much as we can. And whether we like it or not, the law relies a lot on intent. And that's one testimony that their intent is the Emerson's intent is he here. That's all the notes I have. Some comments I want to make before we get into it.
Any other comments by the board or deliberations or questions?
I can see both sides. I mean, really, when you sit in this seat, it's different than when you're on that side. When evidence is presented this way, you can lean that way. But then it goes back to what Mr. Chris said, the intent of the individual. I can't tell you what a person's heart is. And to me, the intent part is, like Mr. Chris said, the law needs to be more specific than it is.
Bill? Teresa? Does anyone want to make a motion to dismiss or sustain the challenge?
I move that the board find the voters not, so I move the board find the voters a legal voter and overrule the challenge.
Dismiss the challenge?
Yes.
Do I hear a second on that? Second. All in favor?
No.
Please raise your hands and say aye. Challenge dismissed. Liars and cheats. Let's take a 10-minute recess before we begin the process of Mr. John Emerson. One day.
Motion, considering the late hours of the night, we're coming up on 8:30. I make a motion that we continue the hearing on John Emerson until the date can be mutually agreeable, so that we'll have time to consider all that evidence. Additionally, my clients have asked, subpoenas were issued in the Tina Emerson case, separate than the John Emerson case. We asked the board to enforce the subpoenas that were issued in the John Emerson case, and that can be done in the interim, so that the board has the opportunity to review that evidence when we do come back to consider that hearing. That would be our motion.
Is the board in agreement to continue the meeting to a future date? We will
I make a motion that we continue to it.
I'll second that.
A date that is agreeable to everyone.
And the board, is the board agreeable that we will consider the request on the subpoenas?
Yes, ma'am.
Does anybody want to bring that to a vote? Or is everybody willing to say yes to that or no? Is there
I'll
not
make a
a
motion that it will be our discretion, or that we will consider it, the enforcement of the subpoenas.
I'll second that also.
all in favor? At this time, we will adjourn this hearing, and we will get back with you, Mr. Moore, and our attorney, and try to find a date. It's kind of hard with the schedules. We've got one stops going on. We'll start. We've got to have some people know at this point in time, and many schedules that conflict with one another with the attorneys as well. So we will continue into a later date. We will try to find a available date that is good for Emerson's as well.
Thank you. Can I ask a question, Mrs. Colbert? If you decide on enforcing the subpoena, will that happen before, the next agreed upon date, or the next agreed upon date is when you discuss that? Just so we have some notice that that's going to take place.
That's our request, is that we have the benefit of those records at the next hearing. That's our request, that we have the benefit of those records at the next hearing.
Yeah, oh, yes, and the schedule would be determined by the Superior Court judge who reviewed the petition to compel.
And so do we have a right to contest that, and have a lawyer go there to the court and contest that?
Yes.
Okay. So that's why I'm asking, just to know in advance, please. Thank you.
You're welcome.
And we will be served that.
If you decide to do it, it hasn't been determined at this point.
It has not been determined at this point in time.
And I'd say there's a straight face with everything's going on. I'm not trying to be cute, but at which address do you wish us to serve you with the notice?
We get all of our mail at 641 Swarnkop Lane, but I will tell you, we are going on vacation and flying tomorrow to Arizona, so we will be gone for about a week. So if anything happens, we will not be there to get, we will not be here, we will not be there, we will be in Arizona.
Merry Christmas.
All in favor?